Roman, welcome at the second stage of the selection to the High Qualifications Commission of Judges of Ukraine at the interview stage. So the commission in its full composition is conducting the interview. That is Steven Markman, me, Ivan Mishenko, Serhiy Verlanov, Tadzadzhechny, Robert Brookhuizen, and Yevhen Mezentsev. The rapporteurs are me and Steven Markman. Roman, so we will keep asking questions. We will take turns, and please give concise answers to the core of the matter, since it quite often happens that there are a lot of questions and there is too little time. So every member of the commission is entitled to limit the time of your answer to this or that question, and in case the interview is interrupted for any technical reasons, we will reschedule it for the other day. And now let's start, and traditionally we start the interview with giving an opportunity to the candidate to tell about his motivation, about the ideas the candidate has concerning the functioning of the new HQCJ and the judiciary in general. That's why, please, the floor is yours. Up to 5 minutes. Thank you. So, just in brief, let me introduce myself. After I graduated in 1986 of Dibrovar 8-year school, I entered Brode teacher training school, and I finished it in 1989, where I got the specialty of the teacher of drawing and physical training. And I served in the armed forces, and then after I came back, I studied at the House of School Children Training or Culture, whatever the name of it is. And then I worked in my village, Dibrova, at school, and that was already law studies. I was the teacher of law because I was the student of the law faculty. After I graduated from the faculty and got the diploma, I worked at the prosecutor's office, and then I came back to my teaching activity. And since 2003, I have been the judge. Over the period of 2003-2011, I worked in Chernovinograd court, and since 2011 up till now, I have been a judge of the appellate court of Lviv region and Lviv appellate court at the moment. My motivation. Well, I also would like to say that I presented my PhD thesis. And over the period of work in the appellate court, since 2013 up till 2018, I was also teaching at the Department of Medical Law in Lviv National Medical University, named after Danilo Halitsky. And now I also deal with some scientific academic activity, but for it not to prevent me from doing my main job. My motives for applying for the HQCJ are as follows. On the 23rd of June 2022, the EU countries voted on granting the candidate status to Ukraine, but this status presupposes a number of reforms that have to be conducted in the country. These are the requirements of the EU. There are 7 blocks or 7 sections of requirements Ukraine has to meet, and they include the reform of the judiciary. As far as the reform of the judiciary is concerned, I would like to say that we all have to deal with this, and in particular, this is all about the competition, the selection for the High Anti-Corruption Court, which was established with the help of foreign experts. Also, the selection to the HCJ, the selection also involved foreign experts, and this is the selection to the HQCJ, which we are now having. Of course, the competitions, the selections are really important, particularly the selection for the HQCJ, because depending on how we conduct this selection, what people are appointed, the judiciary, of course, will be affected by that. Since I have teaching experience, I have experience working with school children, with students. I've got scientific experience and 20 years of work record. And that's why I think that I am eligible for being a member of the HQCJ. Thank you. Thank you, Roman, for your introductory speech. So let's start the interview itself. In your motivation letter, you indicate that to increase the level of trust in the society, in the judiciary, it's necessary in particular to introduce the national concept of communication of the judiciary. Here is my question. You know, now almost all courts have web pages. For example, I entered the Facebook page of Lviv Appellate Court, where you were quite a good web page. Also, courts have judges speakers. Quite often, judges communicate in different formats with mass media, giving interviews and so on and so forth. The Supreme Court has got a Telegram channel where it communicates about some important decisions taken. So what should this concept include, what we don't have now? In what will this concept be different from what we now have? Well, you know, communication is one of the points that should be introduced in order to increase the level of trust in the judiciary, in the judicial system, and in the state institutions as such. But communication is probably not the most important thing. The most important thing is how to increase trust in judges, in courts, and in judiciary in general. We should first of all focus on the issue of trust in the newly established bodies, like the HQCJ, HCJ, the newly established High Anti-Corruption Court. And this all depends on how we conduct those selection processes and and what people are selected, what people are appointed. The public should see that the selection is transparent. And I indicated in the motivation letter that the fact that we have foreign experts on the commissions will already increase the level of trust in the people who are appointed, who are selected for being members of the HQCJ. So first of all, it's all about raising the level of trust in the institutions which are now being established in the course of the reform. And later, at the later stage, this is also about improvement of the mechanism of communication with the society, with the Public Integrity Council. It should involve online trainings. And there could also be introduced courses of foreign languages for judges, because I think that that will also increase the level of trust. Thank you. I've got the answer to my question. In your motivation letter, you also indicate that you are not better or worse than the other candidates who have applied for the HQCJ. Then why should the selection commission prefer you as a candidate? Well, you know, the selection commission collects information about the candidate, and I think that you have studied everything about myself. And I just hope that you have collected all the information on the basis of all sorts of materials, and you have asked me questions and provided explanations. So I think that the selection commission really knows a lot about me now. And at the same time, in my motivation letter, I also indicate that I have quite an experience of working with school children, with students. I have some scientific achievements. I have 20 years of judicial work. So all this yields in both positive and negative characteristics, which actually allow me to be candidate for membership in the HQCJ. That's what I meant. You know, Roman, this is not the first reform taking place in the Ukrainian judiciary. Could you tell me what reform that has already taken place has been the most successful and why? And which reform has really failed, as you think? And give the reasons why you think so. Well, I was involved, and the Commission knows this, in the competition for the judge of the Constitutional Court and judge of the Supreme Court. And I was also following the competition to the High Anti-Corruption Court, and I was following the process of the Ethics Council with foreign experts determining, being this predetermining filter, deciding whether the candidate can be the applicant for the position or not. And I would say that selection processes with the involvement of foreign experts, and I think that the public would agree with me, as for now, are the most effective ones. They are the most objective, and the decisions are trusted. The failure, well, the reform that has failed, I could probably not point out any reform that has failed the most. Okay, let me rephrase my question. If all those reforms have been a success, then why has the level of trust in the judiciary not increased? Why has it not increased? Well, you know, that is according to the analytical data, recent analytical data provided by the leading American editions that show that the level of trust in the judiciary is really low. And I think that both now and later, when the members of the HQCJ are already appointed by the HCJ, will become a certain contribution to the increase in the level of trust. Maybe when proper people, adequate people are appointed to the HQCJ positions, maybe that will lead to increased level of trust. So you mean that this commission has a certain secret which was not there before? Well, let me try to express my idea why so many people have applied for the competition. I think that actually that shows that everybody is trusting more and more in the selection processes. And I think that when members of the HQCJ are appointed by the HCJ, the level of trust will also increase. There is such an interesting phrase, credit of trust. And I think that the credit of trust is predetermined by the number of likes among the public. Well, let's hope that people will come to like the new reforms. And let me give the floor to Stephen Markman, co-rapporteur.
Thank you, Mr. Chairman. And thank you, Judge Savuliak, for participating in the competition. I'd like to cover a couple things that my colleague just covered here because I think they're really quite important. Concerning communication, first of all, that was a subject of some focus in question number 8 of the motivation. And when I read that, I thought about the politics in my home country in the United States. Seems to me that often it's the case that the losing party in a campaign for this office or that office responds to the loss and says, we had a good message, but we just didn't communicate it very well. And that's what I'm interpreting you as saying here. We in the judiciary of Ukraine have a good message, but we're just not interpreting it very well. We need to strengthen our communications apparatus. We need to do a better job in communicating to the people of Ukraine. But the people of Ukraine fairly consistently over many years have said, we don't have the high level of trust in the judiciary. And I'm wondering if the possibility is they don't have that high level of trust because not all in the judiciary deserve that trust. I thought that was kind of the rationale for the selection commission here. Am I wrong in even thinking that?
No, I would agree with you here. You're not mistaken. And let me stress it once again, that the level of trust in their selection process is higher because of the involvement of foreign experts in it. And this newly established HQCJ composition will have this credit of trust I've been talking about just because it has been selected by such commission. It will be one of the factors for the increased level of trust in it. And these people will, in their turn, work at the communication of the messages, which will also increase the level of trust in the judiciary. You know, the level of trust is sometimes created by sociological groups, and they do it sometimes to the order of some companies. But if we have surveys in the courts of Ukraine, as we have done many a time, and if these surveys include the respondents who have been going to courts, the figures would be different. I mean, people who have really been to courts. Even if we take like 1 out of 100 cases among the people who have attended courts, they don't trust the judiciary. I haven't had many cases in my practice when people do not trust courts. I mean, people who have really been to courts. And I've worked as a judge for about 20 years. So I think that it all depends on the way you communicate with the people.
Well, I appreciate what you say about the internationals and how that's communicating a sense of trust, and I hope you're right about that, and I hope we'll live up to those expectations. But in the end, it's not going to be the internationals who are going to increase the level of trust, I believe. It's going to be the candidates that are selected and are placed on the bench by the High Qualifications Commission, I suspect. If they're the right candidates and they become the right kind of judges, it will be they who will generate greater trust in the system. Is that not correct, or am I missing something important here?
Thank you for your question, and that's what I was actually stressing. Now it's the international experts, but of course, you're going to introduce new members of the HQCJ, and these will be the people to conduct qualification assessment, and it will be them who will have to bear this burden of responsibility to the society, because they will need to increase the level of trust in the judiciary. We must have judges with high level of trust.
So it will be I'm sorry to interrupt you, but it will be the judges who will communicate to the people of Ukraine that the system deserves trust, not the fact that we have better people in our communications department who are more energetic. Is that a correct statement, or do you have something you'd like to add to that?
Well, I think that primarily it is judges who are supposed to give this message, to communicate this message. But the press centers and the communication departments working in courts are also responsible for that. And in our appellate court, we have the practice of inviting special communication officers and 2-hour court hearings in high-profile cases, and they write posts, they write articles. We try to do this, and this is done in order to increase the level of trust in the court.
Judge Savuliak, you have been the focus of a large number of complaints over the years. I know I'm not calling something to your attention that you're not aware of. You've had a number of complaints directed toward you, and I'm aware that I think without exception those complaints have been dismissed. It's not been found that you've conducted yourself unethically or inappropriately in the courtroom at all. But still, there have been a lot of complaints. What accounts for that? Have you ever asked yourself, why am I generating these complaints in the first place? I'm exonerated by the higher courts, but still I'm doing something that perhaps is wrong in contributing to the number of complaints in the first place. Have you thought about that? Have you come to any conclusions?
Well, High Council of Justice has not been working for about a year already, so now I don't know about any claims against me. But of course, I know that there are a lot of claims, but I think it's not only about me, it's about a lot of judges, a lot of complaints are filed. But in the course of the work of the High Council of Justice, they always provided substantiated answers to different claims, to different motions. And over the period of my work, there has been not a single case when some disciplinary proceedings were initiated on those claims, which means that these claims were recognized to be ungrounded. In civil proceedings, there will always be a party that is dissatisfied. That is the party that has lost the case. And since they want to have their cases considered further in the cassation court, they normally file claims. And I've got just recently a claim in one of Lviv newspapers, where the party disagreed with the decision of the court. Of course, if there is a claim and it is filed to the High Council of Justice, it will be considered and let them decide. So I cannot tell you more. I don't know how many claims are now against me because the Commission has not been functioning. The High Council of Justice has not been functioning. I could probably explain something as to any specific claim if you have any questions concerning them.
No, I was more focused on the general trend, the general tendency. Clearly one of your strengths, Judge Savuliak, and I suspect if you were selected for the high qualification commission, it would be a significant factor, is your experience. You have very impressive judicial experience. But I do have to ask you, if you are placed on the commission, what exactly would that experience lead you to do or not to do? You've seen reforms come and go over the years. You've seen reforms that were more successful and less successful, and yet it still felt necessary to embark upon the present reform. What have you learned from your experience? What have you been taught from your experience? What counsel will you give to those on the commission who don't have your experience? What guidance will you give them? Do this, but try not to do that because that hasn't worked. What will you share with them on the basis of your undeniable experience?
Well, thank you. My first diploma is teacher. So this means that I studied psychology, I studied pedagogy of children, psychology of children. I used to work with school children from the 4th grade to the 9th grade. I used to work with students of medicine. And, they are supposed to become doctors, but if you make them interested, they start learning law. They admire it. I've also got the experience of working in the State Examination Commission because for 2 years I used to be a member of the State Examination Commission of Lviv National University, my alma mater. I was the chairman of this examination commission, which took the exams. And during the exams, of course, we had to discuss the strengths and the weaknesses of all the students, all the graduates, would-be graduates. So I've got this experience, and in combination with the work of the judge, if we combine like the experience of working with judges, school children, and students, I think that I can give some practical recommendations. If suppose I am elected a member of the HQCJ for the course of collecting information about a certain person, and I would say that I would just keep working the way I work, because I can see that your commission has really collected a lot of information about every candidate. I've looked through it, but I would say that I would follow your example. I would work the way you work. I would follow your procedure. And I would encourage members of the HQCJ to have some trainings, to involve psychologists and before they actually start qualification assessment. These should be trainings for judges before they have this qualification assessment. Well, I will just share my overall experience in case I get this honor of becoming a member of the HQCJ.
Okay, well, I appreciate your thoughts on that, Judge. Let me turn you over to my colleague, Judge Mezentsev.
Thank you, Stephen.
Good afternoon, Roman. Let me continue communication with you. So let's start with the questions we have got as a result of the study of the materials submitted by the National Anti-Corruption Bureau and civil society organizations. In particular, it has been noted that for over a certain period of time, you did not declare the land plot located in the village of Resnaruski. And on that land plot, there is a house that belongs to your son. You just indicated the number of that land plot in the section of incompleted construction. How did it happen so, and why did you not indicate that you have the right of using this real estate? So the agreement, and I will tell you what kind of agreement it is, was concluded in 2013. That was the agreement of donation of the land plot. My son was not residing with us at that time. He was the student, and he stayed in Kiev at the time. But as a judge, I had a duty to declare this property, regardless of whether he worked with us or not. He did not reside with us, but I declared all his property and his income. And since 2013 to 2015, I really declared in the section real estate facilities and land plots, this land plot which belongs to my son and which was designed actually for the construction of his own house. In 2016, the house was built. I work in the civil chamber, and I understand actually what the legal standpoint is concerning the unity of land plot and the construction facility. They become kind of united property. Maybe that was a mistake, but I just declared this very land plot within the section of incomplete construction facilities, which means that before 2015, when the house was not yet built, I declared it separately, but when the building was already constructed, although it was not put into operation, I actually declared this very land plot in a different section within the section of real estate facilities. like incomplete construction facility that has not been put into operation. But I declared it all the time. Maybe I need to make a request, an inquiry, anything I was showing, whatever I have. If it was a mistake, maybe, but I at least indicated it in some of the sections. Another concern of civil society organizations is about the fact that you and your highly respected wife got 2 land plots in the village of Dibrova, which is the village you originate from, in 2000 and 2005. And the stress is on the fact that at that period of time, the head of the village council was actually your father. What explanations could you provide on that point? Is it true? Or maybe something has been mixed? Well, let me explain that since actually till 1998, I was a teacher of Dibrova school. And in 1995, there was division of the land plots of the farm that we used to have in the village of Dibrova. And of course, according to the law, the members of this collective farm had the right to get a land plot, a certain share of that land plot. I was not a member of the collective farm, I was the teacher. No, you were not a teacher, you were assistant prosecutor, according to our data at that time. No, that's about not the registration of these land plots, but division of the land plots. That happened in the period of 1992-1998. And we got the certificates, but the ownership was registered and could be registered when I already worked in Червоноград city court, and here is the state certificate. No, you shouldn't provide the data from the certificates to the camera. Please don't show the document to the camera. Well, sorry for that. Well, that's about your security, not ours. I'm not afraid to show the documents about the land plot. And I actually told my father that there are some claims in this respect to me, that there are some concerns. He really used to be the head of our village council, but he stopped being the head of the village council in 1996. I'm proud of my father because he was the head of the village council for 6 terms. And, you know, if he actually did something wrong, nobody would have elected him in 2001 again, the head of the village again. You applied twice for a judge of the Constitutional Court of Ukraine, 2017 and 2019. Am I right? Yes. In 2019, when you applied for this position, were you a delegate from your court to the Congress of Judges, which actually settled the issue of election, or no? 2019, well, I really applied twice. I don't remember. The procedure was as follows. At first, the Council of Judges invited all the candidates who had applied, and the Council of Judges selected some candidates who were allowed to participate in the Congress of Judges, so I was allowed to participate in that Congress. I was not a delegate. Yeah, okay, it's clear. I've got the answer. This is just clarification. So in 2019, you got 3 votes in your favor at the Congress, with due account of the fact that there were 300 delegates. So how did it happen so? Was there no pre-election campaign, or you're not well known in the judicial community? Why 3 votes out of more than 300 candidates? The result is not impressive. Did you analyze the situation? Of course I did. Probably I should have had more communication. I should have gone to different districts to explain my agenda, my motivation. But you know, the Council of Judges, when I reported on my vision, selected me out of many other candidates. According to my data, there were about 20 candidates, and the Council of Judges selected 8 or 7 for voting. So somehow the Council of Judges selected me, but there at the Congress of Judges, I really failed to convince people to vote for me. Thank you, Roman, for your answer. You know, quite often we are also addressing the following issue, and let me ask you, because I want to listen to what you think on that point as a judge and probably as a potential member of the HQCJ. If you were assessing judicial candidates to be appointed for the first time, what would be your concept for that assessment? What will be the key rule? Like to consider all the candidates not people of integrity and to lay this burden of proof on them, or vice versa, to have this presumption of innocence principle and to put this duty of proving that the person is not a person of integrity on you and the commission? What would you choose? Thank you. It's a difficult question. I think that one of the drawbacks of the previous composition of the HQCJ was that communication with the Public Integrity Council was not quite good. There were a lot of cases when there was a conclusion passed by the PIC and then it was revoted. No. Let's put the Public Integrity Council aside. It has nothing to deal with the context of this question. What principle would you ground your activity on? Presumption of integrity or presumption of lack of integrity of the candidate? Exactly for the task of studying the characteristics and qualities for appointing this judge for the first time. Would you be very scrutinous or scrupulous, or would you be more lenient? Well, of course, I was trying to be more rigid, but fair, just. And as far as these two presumptions are concerned, whether it's presumption of innocence, of integrity or lack of integrity, I would say that I would use presumption of integrity. Okay, thank you. Let me give the floor to my colleague, Robert. Robert, please, the floor is yours.
Can I help you?
Thank you.
No problem.
Good afternoon, Judge. I've been reading, of course, the information you have provided to us. And in your motivation letter, when asked about your motivation to participate, you say that you have awareness of the need for changes. And then I started looking in the letter, what was the need for changes according to this letter. And then I only found a better communication and selection via a selection procedure. Well, selection via a selection procedure is already there, and better communication, maybe the judiciary can solve by just hiring a communication expert. So what would be your added value if those are only the need for changes in this commission? Why would we select you if these are the only problems to solve?
Thank you for this question. It should be understood that the mandate of HQCJ is specified in the law, and this includes selection of new judges and doing qualification assessment of the incumbent judges. There is the methodology of qualification assessment. We need to be working within those competencies, within the mandate foreseen by the law. We cannot go beyond the limits of this mandate. So I meant establishing the procedure of work of HQCJ as far as collecting materials about candidates is concerned, compiling the dossier, being more scrupulous about analyzing negative data, negative facts about this or that candidate. And consequently, we need to conduct impartial qualification assessments. So there are no other things that should be mentioned.
But that's not my question. My question is that you write in your letter that you have awareness of the need for changes. I read this, but maybe it's a wrong translation, that there is the need for changes and that you are aware of this need for changes. The question to you is, what is the need for changes and why? What needs to be changed?
First of all, we need to have better communication with PIC. And in general, we must be performing our duties in a duly manner, following the requirements of the law on the judiciary and the status of judges. What else can we add other than the things that are already foreseen by the law? So we are collecting data, we are analyzing the judicial dossier, we are holding qualifications assessment, we are assessing professional competence and integrity, and the professional ethics. Maybe we should be doing these things in a different way so that we can enhance the level of trust. And everything is done under the scrutiny of the civil society, and I mean that the civil society must know absolutely everything about candidates. Everything must be very transparent.
Okay.
We are not lawmakers. We cannot introduce changes to our laws. And I mean the law on the judiciary and the status of judges, and we have the mandate prescribed by this law.
Yeah. Well, if I listen to you, I'm sorry to interrupt you, but if I listen to you, I hear someone who works in the law and as a judge for a long time. And when I listen to you, what you say is the laws are there, the procedures are there, we just have to do them better, which I wouldn't describe as the need for change. I would describe this as to do the work better. The point is, Judge, that again, the reports suggest that trust in the judiciary is...
Yes, but if we have amendments to the law, we will be working according to those amendments. And at the moment, we should be working within the effective legislation, within the existing mandate. Because the law already has this methodology for assessing the candidates,
Okay.
the methodology that we should be using.
But so what you, if I, let's say, okay? Well, if I read in your letter awareness of the need for changes, if I translate what I think you say to us is, let's do our work better and then everything will be okay. Is that what you say to me?
Probably yes.
Okay. And the point is that the trust in your judiciary is very low. If you just go on doing what you have been doing the last 20 years, in the next 20 years, it will be exactly the same. The history is always the best prediction of the future, many people say. So if you don't change anything, then nothing will become different. It will remain the same, isn't it? Then in 20 years, there will be the same commission again, and we will sitting here all together discussing the same stuff. And the reason for that is that we selected people who said, well, everything is in order, we just have to do our work a bit better. better explain maybe a bit, better communication guy. This doesn't give me trust, does it?
Thank you for this question. I'm still insisting that the effective legislation does not foresee any other mandate for members of HQCJ other than those that we currently have in the law. And I cannot give any promises as if I were running for office just for you to like me or for the audience to like me. But as a member of HQCJ, or as a future member of HQCJ, I will be acting only according to the way specified by the law, using the methodology approved by HQCJ.
Okay, thank you. I will please pass the floor to my dear colleague, Ted Sazetsny.
Yes, good afternoon, Judge. I still do not understand, and I hope you can assist me to do so, the transactions that you speak of in your motivation letter in answer to paragraph 5 and our question there. You say that your wife Maria and you have agricultural land plots in the village of Dubrova, Belska, and a house in the village of Ryasna Ruski. Now, speaking about the land plots, when did you acquire those land plots? You and your wife, the agricultural land plots.
The procedure for acquiring land plots in Ukraine is specified by our law. And when we were having parcellations done in the village where my wife and I worked as teachers at a local school, that happened back in 1995. So there was parcellation of land, of agricultural lands. So at that time, my wife and I were teachers at school, at the local school. And according to the Ukrainian law, not just the agricultural workers, but also educators, cultures, experts have the right to land plots. And those land plots were transferred to us as people working in the social sphere. At the time, I was not yet working at the prosecutor's office. I was not a judge, and I received a certificate giving me the right to those land plots. And I received ownership. I registered those land plots much later, in 2005. And my wife registered ownership in the year 2000, when I was working in the trial court. This is our legislation. I could refuse my right to get this land plot, or I could have accepted it, which I did. I was born in a village, and if it was unlawful, if it violated the law, people in the village, they would not understand that. I would not be allowed back into my village if I did something like that.
Yes, that's, yes. Excuse me, Judge. So, Prior to the parceling out of these agricultural lands, who was the owner of those lands?
It was the village union.
All right, that I assumed that, but I needed to know that. Now, when you received the certificate that you speak of, you and your wife, was your father on the village council of the village, Dubro?
Yes, my father was on the village council of the village of Dibrova in the year 1995. He was the head of the village between 1980 and 2006. So he was elected the head of the village 5 times. Yes, that's what happened.
Yes, and so when you received the certificate for the land plot, your father was the head of the village council. When you registered, you and your wife in 2000 and you in 2005, your father was still the head of the village council. And did the village council have to approve who received these land plots?
Yes, the village council had to approve it, but I actually was not really interested in that procedure. I don't know whether my father voted on those procedures. Maybe he recused himself. But I don't know really about the voting, but the village council had to adopt some decision. So it was first the decision of the village union, and then the village council had to vote for these land plots to be given to us. And then the decision is made by other authorities, including district administration, which is above the village council.
Yes. Now, let me ask you this question. Did you have to apply for these land plots?
In 1995, yes, I had to apply to get the certificate. Yes, there was a kind of document that I had to write.
All right. No.
And as far as the certificate is concerned, I don't know the procedure.
Right.
Yes, but I had to apply in the year 1995 and in 1997. Yes, there was some kind of procedure.
All right. The other question I have is somewhat related, but it is dealing with the land plot that your son became the registered owner of. And if I understand the information that you have provided, that is the land plot on which you and your wife constructed a house. Is that correct?
Yes, that's correct.
Now, your son, you say, was in school at that time. Where did the money come from for your son to purchase that land plot?
Yes, my son was a student at that time. He studied at Kyiv National University.
Right, and you don't provide. There was a donation agreement, and who donated that land to your son?
It's a difficult question for me. When I was asked this question by the selection commission, it was difficult for me to answer. Because I'm not party to that transaction. I'm not party to that agreement. The parties are my son and Miss Kuryliak. But I'm not going to hide anything from the selection commission.
Let me interrupt you. Was this wasn't the one we went in camera on, was it? All right, sorry. I was just asking a question of our chairman. Continue then. This donation agreement was who donated this land?
So it was Lyubov Kuryliak who donated this land to my son. It was a gift agreement. So while I was judge of the appellate court, I've been judge of the appellate court since 2011. My wife and my 4 children stayed back in the town of Chervonograd, which is located at a distance of 85 kilometers from Lviv. So one of the motives for me to transfer to Lviv appellate court was the possibility to get an apartment or some kind of credit because I have many children. And in addition to my wife, I have 4 kids.
Yes, you have provided us with that explanation already, so we are aware of that explanation. But my point, I guess, is this: why did whoever the grantor of this gift was, why was it registered in your son's name?
That was the will of the donor, because we were on good terms with her. And I approached her as a specialist from the village council. I asked her about the possibilities for buying a land plot, and she kept silent, and then a little bit later she offered me the land plot that she owned. It's hard to tell you about these things before applying for this selection. Well, when I received your questions, actually, I asked Luba whether it was okay if I disclosed that information, and she said it was fine. So I'm telling you the story. So it was the land plot that her son owned, and he tragically died. And that land plot was not used for 10 years. And Luba knew where I was working, and she said it was not going to be a problem. She wanted for the land plot that belonged to her son to be owned by my son. And because I had 4 children, she said that I could use that land plot to build a home for all my kids. And she now knows that we constructed this house on the land plot that her son used to own. That's the information that I was allowed to disclose by the previous owner. If you asked me if I would do something like that right now, then probably no. When getting ready for the interview, I read the Code of Ethics, the Code of Judicial Ethics of the United States, and it's mentioned there that a judge cannot receive gifts. And it has to do everything that no members of their family receive gifts. But in view of current circumstances, I would not have accepted that gift. But at that time, it was something I needed to do to build a home for my family. Thank you.
All right. Thank you for your answer. I'll turn the matter over now to you, Mr. Chairman.
Maybe Sergey.
We have Sergey.
Yes. Pardon me.
So, you turn over to me, and I turn over to you.
Yes.
Дякую. Пане Роман, у мене будуть до вас такі запитання.
Roman, I have some questions for you.
Будь ласка, в своєму мотиваційному листі
In your motivational
ви вказуєте про те,
letter,
що для підвищення
You say
рівня
that in
довіри до
order
судової
to
системи
enhance
ви,
trust in the
пропонуєте,
judiciary,
зокрема, ввести обов'язкову фахову
we need to
підготовку
have
майбутніх
compulsory
суддів,
professional training for judges at specialized school, at specialized schools. This is me quoting your motivational letter. Could you please
З приводу
explain
даної вашої пропозиції?
what is the essence of this proposal of yours? What do you mean?
Є школа
We
суддів,
currently have the
Національна
National
школа
School of
суддів, яка,
Judges in
відповідно до
operation, and according to the requirements of the law, they are providing this training for candidate judges,
Що ви мали на увазі?
where candidate judges receive this training over a year's time. What I meant was training at the National School of Judges for candidate judges. But I think we should also pay attention to specialized departments at different universities and law schools, where we could have this kind of specialization. Training in judiciary. So these departments could train students who want to become judges. For many years, I taught at a medical university, and they have this combination of theory and practice starting from the third year of studies. Medical students are constantly present in hospitals, and they are involved in some minor interventions, providing first aid. So I was talking about a combination of theory and practice at departments of law schools, starting from the third year and up until the master's year.
Ви це порівнюєте безпосередньо з вищим
So
медичним
you are
навчальним
comparing
закладом,
it
які
to
практикують.
a medical school where students combine theory and practice. That's clear. Thank you. My next question.
Ви от пояснювали зараз і моїм колегам з приводу
So
того, що
you
ви,
were just
вже маєте досить великий
You were just
досвід,
telling us that you
як
have
до,
vast
призначення вас суддею,
experience
так і вже фактично
of
19
being a
років,
judge.
з гаком маєте досвід суддівський.
So you've been a judge for more than 19 years already. So could you please tell us, over the course of your career, have you had any experience of selecting people? Selecting
Взагалі, я маю на увазі.
judges, you mean? No, just selecting people in general for different positions.
І кого саме ви відбирали?
And who did you select? In addition to having exams at school and at the Department of Medical Law, where I used to work, we had different contests checking the knowledge in the sphere of medical law. So I was a member of the jury. I was selecting students. I was trying to select the best students based on their presentations. I was member of the state examination board that awarded diplomas to lawyers. And I also wrote some academic papers.
Зрозуміло.
Yes, but I'm in general interested in these questions.
Ви як суддя відбирали собі помічника?
So, as a judge, have you selected your assistant? Yes, of course. So, what were the criteria that you used
Звернувся для того,
to
щоб
select your
бути
assistant?
вашим помічником.
I I have just one assistant. Yes, that's clear. But I'm asking you about the criteria for selecting the assistant. I currently have two assistants, actually. They are very good people, and I trust them. But if you ask me about criteria, that's professional competence, integrity, and ethics. We want for them to become judges in the future, that's clear. But how do you assess whether they are professional, whether they have integrity? From your personal experience, just share your personal experience. How did you assess them? How did you select those assistants? So you get acquainted with the person, you give them some tasks. Of course, you don't become an assistant overnight. And I used my pedagogical skills. I was trying to get them interested. And when I saw that the person was good at writing, core decision was having good communication skills, that the person was responsible, that it was possible to rely on her during stressful situations when the deadlines were tough, when we had to make a draft decision, let's say, and include it into the registry. I also assessed the attitudes the person had both to her professional life and personal life. That's clear. Thank you, Roman. Now let's go back to you as a candidate for becoming a member of HQCJ. Could you please tell us what qualities of yours should tell us that you are a better candidate amongst those that we have? What should tell us that you are a worthy candidate? This is experience of practical work, experience of being a judge, a teacher. So these are the qualities that give me grounds to become a candidate. So, and how do these qualities characterize you? So the qualities that you've just mentioned, what kind of criteria do they characterize? Apparently, these are the criteria that we have in the Bangalore principles, in the Code of Judicial Ethics, the criteria necessary to become a candidate. So let me help you. This is the criteria of professional competence. But if we discuss the criteria of integrity, what qualities do you have that will tell us that you have integrity? As far as integrity is concerned, let me define what integrity is. There is no definition in our legislation. And when getting ready for the interview, I was trying to find some definition. And again, this is the experience of the United States of America. And with them, integrity is following the Code of Judicial Ethics, moral principles, being just and fair, both in professional life and in everyday life. And I mean family, probably. And let me help you once again. So if you went to our website, if you went to the website of the High Council of Justice, the HQCJ has published the methodology for assessing candidates who want to become members of HQCJ. And there you will see that integrity includes honesty, diligence, ethical behavior, financial standing, being diligent about your work. So there are 8 components to the criteria of integrity. So which of those apply to you? With respect to these criteria, I believe, and I wrote it in my motivational letter, I believe that I meet the criteria, and they give me grounds to believe that I can be appointed a member of HQCJ. So I have independence, impartiality, diligence, excellent behavior, my financial standing causes no questions. So you meet all the criteria. Yes, I believe that yes. Thank you, Roman. So these are all the questions that I've had for you, and I'm passing the floor to our chair, Mr. Ivan Mishchenko.
Questions, colleagues?
If I may.
Of course.
Пане Романе, я хотів би у вас поцікавитися таким питанням. Відповідно до декларації
So let me find it out from you. According to your declaration for 2020, in March you acquired Opel Zafira, which was 11 years. It is not Geländewagen, it's just a budget car and quite a used car of 2009. And the cost is 68,200 hryvnias, which is about $2,700 at that point of time. We take the current market of cars in Ukraine, so it is 157 cars like that, Opel Zafira of 2009 year of make, and the cheapest is 5,600. What is the ground for such a small price? Was it a damaged car, or was it a Euro car, or which you brought without customs clearance, or what? Thank you for the question. That was the year 2020, and before that, our family didn't have a car. We had to provide for the studies of our children, to have some apartment to live in, but then we needed a car to complete the repairs of the house. Okay, it doesn't matter. I'm not interested in the reason why you bought it. I'm just interested in the price. The fact that you are allowed to buy a car, well, nobody argues. Your income allows you to buy a car. I'm just asking, what about the price, the declared value of the car? What could be the explanation? So the car was bought under the purchase sale agreement. Unfortunately, after I got your request, I tried to find this agreement of purchase sale, and I addressed the state traffic inspection where I registered it, but they registered the car under the agreement, and I saw the amount for which I had to buy the car. That was the car brought to order, and it really corresponded to the status which was indicated in the documents. But that was the real cost of the car. It was a bit damaged, and well, I could have indicated larger value or not to have any questions, but I just indicated the real value. The car was brought from abroad. Okay, that's enough, it's clear. Don't try to provide such extensive explanations. To just explain that I brought it from abroad. It was the car brought to order, and that was its real value, and there was zero customs clearance. So no problem about that. I've got your answer, thank you. Yes, and it's all according to the data of the documents. We were looking for the cheapest and the most comfortable car. Thanks God, nobody objects to that. And to conclude with, today, you know, I have a trend to ask trivial questions, so let me ask one more. Just imagine the situation that you are a member of the HQCJ and you're approached by a friend of yours, a very close friend of yours. You studied together with him, he's almost your relative, the godfather of your son or daughter. He's a close friend of yours, a soulmate. And he claims that his son will be participating in the judicial selection. And he wants you to be very attentive to this candidate. What about your actions? What will you do? Well, what I will do, I will immediately write self-recusal, announce self-recusal if this is really a person with whom I have some close relationship or family relationship. Definitely, I will announce self-recusals. I mean, I will ground and substantiate the application for self-recusal. There can be no other way out. And of course, no promises. But what will you tell your friend then? Well, I will explain it to him that, you know, we live in the times when you cannot be solving questions in that way. Well, in a way, yes. I will not be solving the issue in that way anyway. Okay, we ask this question quite often, you know about that. And to tell the truth, I always want to hear the answer that, okay, my close relative or my close friend will never approach me with a question like that. That's what would be the preferred answer. Okay, thank you.
I believe no further questions, right?
So, Roman, our interview is going to be over, and the Selection Commission gives you now an opportunity to sum it all up. If you want to stress some things or to add something for us and for the audience, please, you're welcome. The floor is yours. Thank you. So, to conclude, I would like to express my gratitude to the members of the Selection Commission for the care taken by them during the preparation of and conducting of this selection. This is the first open selection procedure for the HQCJ. When you are selecting the members who will be responsible for judicial candidates. Being a judge is being responsible for the decisions passed, because according to the federal judge Orban, the U.S. Judge Court is the last bastion for protection of human rights. And the unprecedented number of applications submitted shows that the society trusts the selection procedures, the selection commission, and future members of the HQCJ will also have high level of trust in the society, will be able to really reform and transform the judiciary of Ukraine and make Ukraine closer to membership in the EU. Thank you. Thank you, Roman. So that is the end of our interview. Good luck. Stay safe. Goodbye. Goodbye. Thank you. Ukraine will win. Definitely.